Hi, hi Eric Markuson. Good morning. May I please admire your typing fingers? Oh, that's funny. That's funny. So today we're gonna do some studying again. We're gonna do multiple choice questions. So if you guys don't see me looking at the camera for a bit, that's just because I'm thinking as to which multiple choice question to pick. But I'm still here. First one, correct. Now let's look at the second multiple choice question. It's what I'm looking at right now. No, I got the multiple choice question wrong. Hi, Gig. Yeah, I'm a student from. Oh, you're from Ireland. Oh, that's so cool. I'm in Manchester right now. Thanks for the thumbs up. I'm in England, law student. Rose says, Rose said, best of luck with your studies. Uni not finished for the year? How come you're still studying? Yeah, my uni. Thank you very much. My uni course is not finished till like September, so yeah, it's a different course. It's a master's degree, so I think maybe it's different. Tamilore Akeju said, "Are you Nigerian?" Yes, I'm Nigerian. I'm Nigerian. I'm Nigerian. Thanks for the thumbs up. All right, I got 2 out of 3 questions correct. Rose said, "Is your master's degree stressful? How many days do you usually travel to uni for classes? Law sounds interesting." So yeah, the master's degree is a bit, it's kind of stressful because sometimes there's a lot of content to learn within a short period of time. And I travel to uni like 4 times a week. Some people travel 3 times a week, depends on how they grouped your classes. And said Rose said law sounds interesting. Yeah, law is very, very interesting. There's different types of law, different topics, and it's actually quite interesting. Different cases and the reasoning in of judges in making decisions is interesting because it actually like shapes society rules, and the way it changes over time is so interesting. What type of law would you like to specialize in, said Rose? I think I want to specialize in commercial corporate law, or maybe real estate. I think I'm finding real estate interesting, but I'm leaning more towards commercial corporate law. Yeah, that's the type. However, I haven't had like experience in all areas of law, like proper hands-on experience. So maybe if I have experience, my mind will change. But so as of now, I really like commercial corporate type of law. Oh, there's two. Okay, Rose said what? Okay, yeah. Thank you very much for the hearts. Thank you so much. Thank you so much for the hearts. All right, I just did 2 multiple choice questions and I got 2 out of 3 correct. It's not that. Oh, I'm gonna try to do the 10 practice questions and we'll see how well I do. And to do these practice questions, I have to time myself as to make sure I'm like replicating the exam conditions of the real exam. So, gonna click the practice test and I'm gonna set a timer of 14 minutes and 42 seconds. For that period of time, I may not look at the screen just to replicate, you know, exam conditions. So I'm gonna put a 14 minute. Hopefully I finish it faster. 14 minutes 42 second timer. Rose said, "What's the hardest part about masters so far?" Is it hard to get a first in assignments? I haven't had assignments as of I haven't had assignments since I started, but now I have deadlines for like September and August. But I think it's usually kind of hard to get a first, I think. So as I would say yes, although I haven't done any assignments yet for my masters. We do them all like due in September, due in August. So technically I'm meant to start the coursework. So I haven't it's not like on the graduate when you do different assessments over time. This one you do it all at the end. So I haven't I don't well based on my experience on the graduate, yeah, I think it's kinda hard to get at first. But I guess it depends on how well you understand the topic, how much you studied, and that's what I think. All right, I'm going to start the timer in 3, 2, 1. Actually, wait a second. All right, we're back. Hello. All right, so now I'm going to do the practice question, and I'm not going to look at the screen for like 14 minutes, 42 seconds, because I'm going to try to do it in exam conditions. So let's see how many out of 10 I'll get correct. Started the timer right now. Exam conditions. Let's begin. In exam conditions, we have paper. We have a whiteboard. So I'm going to use my whiteboard to help you. Oh my gosh. Why is the question not coming out? What the heck is going on? Okay, now. Exam conditions. Now. Thanks for answering, said Rose. You're welcome. No worries. Okay. 10 question. A statute provides that all decisions by a particular public body shall not be challenged in any legal proceedings of whatever nature. A company now wants to take judicial review of a decision which adversely affects its interest 10 weeks after, 10 weeks, 2 months, 10 weeks, 2 months. Oh my gosh, this frantic bad. 2 months after the decision was made. The reason the company waited for 10 weeks before deciding action was the board of the was unsure whether or not it's going to. Okay, so it's undue delay. However, last week your team council was opinion that there were valid grounds for, and there's valid grounds for judicial review. On the company, say judicial review of the decision. No, because even though the outside clause will not protect decisions of the public body from challenge, there has been undue delay on the part of the company in lodging the claim. No, because the outside clause will protect decisions of the public body from challenge. No, no, because the outside clause will protect decisions of the no. This one, as of nullity, correct. Next. Alright. Anyways, which of the following statement best summarizes whether the pressure groups have the requisite standing to challenge government? Which of the following statements best summarizes whether the pressure groups have the requisite standing to challenge the government department's decision by way of judicial review? Which of the following best summarizes whether the pressure groups have the requisite standing to challenge the government department's? Two pressure groups want to challenge the decision by the government to award a contract to a particular company for cleaning up pollution caused by an oil spill from a tanker at the coast of North Devon. The pressure believe that the government awarded the contract to the company because it decided to accept the cheapest bid for the contract rather than more expensive one from another company with a better record of cleaning up oil spillages. The company that failed to win the contract is not interested in pursuing. Suing the matter. To challenge. Alright. One pressure group, the two pressure groups want to challenge the decision of government. Particular company for contract of the pressure group believe the government awarded the contract to the company because it decided to accept the cheapest. Okay. One pressure group, the first pressure group has a long history of campaigning on environmental issues. Okay, this is a bit general. While the other second group has a campaign on a wide variety of issues, but only occasionally on environmental issues. Okay, this is wide variety, and this is about clean up pollution. Okay, focused, I guess. So, number one. Which of the following statement summarizes whether the pressure groups have the requisite standing to challenge the growing department? The first pressure group has standing as it has sufficient interest in the matter, but the second pressure does not. But the first celebration, neither. I think the first one, hopefully, is correct. Okay, cool. A local charity that is exclusively dedicated to opposing the revolution in local hospital services wishes to challenge a decision made 2 months ago by Secretary of State of Health for Health to close the geriatric wing of the hospital. The charity is exclusively dedicated to opposing the reduction in hospital services. Reduction in local services to challenge the decision made by 2 months to close the geriatric wing. Okay. Here's the following statement described where the charity can bring a claim shoe. I don't know. The local charity is exclusively dedicated to opposing the reduction in local hospital services, which is to challenge a decision made 2 months ago. 2 months ago, undue delay by the Secretary of State for Health to close the geriatric wing at the local hospital. The charity does not have standing. The charity does have standing but cannot bring a claim for this because it did not act within 1 month. Decision. You have 3 months for it, innit? 3 months, yeah. The charity does have standing but cannot bring a claim as it did not act within the 6 weeks. No. The charity does have standing but must bring its claim immediately as he has 2 months from the date of the decision. The charity does have standing more and must bring its claim for the charity bill promptly and no later than 3 months from the date of decision. Correct? I hope. But can bring. The charity does not have standing. Okay. Oh, thank goodness. Next question. Is the client able to challenge this decision by word review? An act was passed to prevent fly tipping in the countryside by permitting landowners to put up soft barriers to stop access onto the land. An act was passed to prevent fly tipping in the countryside by permitting landowners to put soft barriers to stop that. Okay. Act was passed to prevent. Soft barriers are barriers that can easily be removed, such as earth, mounds, or concrete blocks. To erect these barriers, however, have landowners need planning permission. From the planning committee at the local authority. A Kent Environmental Pressure Group has discovered a farmer has been given permission to erect metal fencing to deter trespassers. I know it's something to do with 6 weeks. Act has been passed to prevent flying in the countryside by permitting landowners to put up soft barriers to stop access to the land. Soft barriers are barriers that can be easily moved, such as earth mounds or concrete blocks. To erect these barriers, however, landowners need planning permission from the planning committee of the local authority. Okay. The farmer has been able to erect the metal. Okay. Is the client able to challenge this decision by judicial review? A environmental pressure group to put soft barriers to stop access onto the land. Soft barriers are barriers that can be easily moved, such as earth mounds or concrete blocks. To erect these barriers, fly tipping. What the heck is that? Is the client able to challenge the decision by word judicial review? I don't know. Yes, because the law is a public body granting planning permission, which is a public law issue. The client has standing in the matter. No, because although the law is a public body granting planning permission, which is a public law issue, the client does not have standing. A client has discovered a farmer has been given permission to erect metal fencing to deter trespassers. Yeah, how do they have standing? No, because although the local authority is a public body, it is dealing with private law matter. Is this private law matter? So, oh yeah. A client has discovered the farmer has been given permission to erect metal fencing to deter trespassers. Yes, about trespassing. No, because although the local authority it is dealing with a private law matter when granting a planning permission, the client's standing is relevant. No, because by the way a land like this with his property is not public law issue and cannot be usually reviewed. The client's standing is irrelevant. Tricky question. No, because although the local authority is a public body Granting plan evaluation, which is public law issue, the client does not have something. I don't think client standing is irrelevant because there's one case for the allowed it, didn't it? And because although the local authority is a public body, granting plan evaluation, which is public law issue, the client does not have something in the matter. I guess it's this one. No! What's the right answer? Oh, yes. Because the local authority is a public body granting plan evaluation, which is a public law issue. Okay. And the pressure group may be given something in the absence of a more suitable claimant. Okay, my bad. All conditions will need to be fulfilled to enable the man to bring a claim for judicial review. Local authority by law states that dogs must be kept on leads while being walked in the park. A man takes his pot-bellied pig for a walk in the park without a lead. Bro, it's a pig. He is fined for breaching the bylaw. The man claims that the local authority acted without legal authority and wishes to bring a claim for judicial review. He was kept on leads while being walked in the park. A man takes the pot-bellied pig for a walk in the park without lead. Ocean will be fulfilled. The man to bring a claim for judicial review. The local authority must be a public body. The man must be applying on public law grounds. The man must have suffered loss and must apply within 3 months. Yeah. The local authority must be a public body. The man must be applying on public law grounds. The man has sufficient interest in the claim and must apply without undue delay, promptly, and within 3 months of the decision. Correct. The local authority must be a public body. The man must be applying on public law grounds. The man must have sufficient interest in the claim and must apply promptly and within 3 months of the decision of the local authority. What's the difference in these two? Oh, it doesn't mention undue delay. Okay. What are they? What? The local authority must be public authority. The man must be applying for public law and the man must be a victim of no. Oh. No. The local authority must be public authority. The man must be applying on public law. The man must have suffered no. So between B and C. Must be a public authority. The man must be applying on public law grounds. The man must have sufficient interest in the claim and must apply. There must not be undue delay. Please. Thank you. What remedy or remedies should the woman apply for? A local authority has their statutory power to license ice cream vans to sell ice cream within the boundaries. The woman has applied for the local authority for a license to operate an ice cream van. The local authority has refused to consider the application. She has lost money. Mandatory order. Next. Which of the following is correct? The following concerns over the standard of care in nursing homes act. An act was passed for created a new licensing regime. Any new care home must now apply for a license if they wish to open. A company applies for such a license but is refused and now wishes to apply for judicial review of the decision to refuse. Under the Act, any challenge must be brought within 6 weeks. So this is a partial ouster clause. Ouster thing. The company chief executive was away when the refusal letter came. What? Is this now 2 months? What? If the company applies for judicial review the day after the refusal letter and lodges their claim, the day after the refusal letter lodges their claim at the it will be provided the company acts promptly and within the 6 weeks lodging the claim at the admitted court should be accepted. Yeah. The company will automatically be entitled to terminate if successful. No. The company will need to show that they are acting promptly and in any event within 3 months. No, it's not 3 months, 6 weeks. The company chief executive was away when the refusal letter came. It is now 2 months since the decision. If the company acts promptly, another application will be considered. 2 months. No, I won't. Please tell me. Thank you. 3 questions left. 2 minutes. Okay. And the NWFC judicial review of the license fee. In order to address the concerns about the behavior of nightclub door supervision in controlling fashion experiment, passed this act. The act creates an determined conduct authority to regulate the nightclub industry and grant licenses to individuals. Every door supervisor must hold a license from the authority to work in the industry. The Nightclub Workers Federation is concerned about the fee that the authority is asking its members to pay on applying for the licenses, believe it exceeded the statutory powers and have acted in a biased manner. The NWF wishes to challenge this on their behalf. Can they seek? Yeah. Because authorities are unable to judicial review claims and the NWF does have sufficient interest to apply for judicial review. Yes. Okay. Which of the following commission range should the farmer seek in judicial review? The local authority has made a compulsory purchase order in relation to a farmer's property. The criminal authority's rules provide that inquiry must be held before CPO is made. Was not done. City workers have attended the property, and when the farmer refused them entry, broke down the gate and began to set up digging equipment on the land. The farmer applied for use review and was successful. They has made the compulsory purchase order in the local authority workers have attended the property and the farmer refused them entry, broke down the gate and began to set up digging equipment. Surely it's damages. Quashing order here and damages. Mandatory order force them to do something. Please tell me it's this one. Thank you. Last question. Oh my gosh, why the heck did the alarm not go? Dang, I guess I ran out of time. Which of the following best describes... Oh my gosh, let me stop this. Which of the following best describes the remedy or remedies BCS should seek? Alright. One question left. BCS are licensed annually by a local authority. As part of its business growth strategy, BCS took steps to expand its beach chair services within the local authority. BCS are licensed annually by a local authority. As part of its business growth strategy, BCS took steps to expand its beach chair services within the local authority's area. The company's application for a license was considered by the local authority but was refused. The company was, as a result of lost significant amount of money that it could have made, upset by the decision and missed opportunity to capitalize from the increased beach football due to the warmer than average summer. The company pursued a judicial review application. Court found the local authority's decision was unlawful. So, if it's unlawful, is it a quashing order? Oh, and damages. Surely. Beach chair services are licensed annually by a local authority. As part of its business growth strategy, BCS took steps to expand its beach chair services within the local authority. The company application for a license was considered by the local authority but was refused. The company as a result of surely should be this. It's a quashing order. Why not damages? Oh, you cannot recover for loss resulting from breach of public law. Something like that. Okay. Correct option is C. The company should seek a quashing order to quash the unlawful decision of the local authority. The decision is then remitted to the local authority, which should reconsider its decision in the light of the court's ruling. Okay, why is it not D? D is wrong because damages will not be available for these public law issues. Damages are not available purely for the infringement of public law right. Damages are not available purely for the infringement of public law right. I need to remember that. Alright. Let's see the final result I got. Good. 8 out of 10 for this one. 16 minutes and 45 seconds. That's not good. That's not too good. I need to spend 14 minutes and 42 seconds. I spent 2 more minutes than I was supposed to, but we did a good grade. So I am pleased and happy with that. I learned something new. You cannot claim damages for, what the heck was it? Something for infringement of public rights. You can't claim damages for that. And also, when there's an ouster clause in an act, that doesn't mean you can't challenge the public body decision. You can still challenge it if there are valid grounds. So you can challenge things that are illegal. If not, it wouldn't be fair. I understood what I want to say. Hey Ella Dancer, how are you doing? Thanks for joining the live. Today we're just studying a bit for my exam. Thanks for the thumbs up. Oh, Aliria Davis said it's your birthday. Happy birthday to you. Hopefully you had an amazing day today. Happy birthday. Happy birthday. Okie dokie. I'm gonna use something. No worries, no worries. I'm gonna check the progress of my studies for constitutional law. Today, well, in the span of like 3 days, we studied 2 new topics. Okay, I already highlighted one of them. I'm gonna highlight this one and write yesterday's date, 21 of June. So what else do I need to study so I can kind of know anything of this topic? The European Convention of Human Rights and the Human Rights Act 1998. Need to learn both of them, and I think once I learn both of them, I learn devolution, and anything else I think should be okay. I think I don't learn about the Constitution, like qualification, consolidation, all that. Yeah. Or should I just move to a different topic right now? Because I feel like I've been on the same topic for a while. Whew, it's hot in here. Anyways, let's move on to... Oh, what the heck is it? Why the heck is it long? Oh, gosh. Chineke. I hope it's a lot of examples, not much reading, please. Hey. I'll be back. All right. I'm thinking, I don't know if I should study the same topic, like the same topic but different thingy, or study a complete different topic. Don't know. Because this is long. This is long. This is long. Actually, it's not just long, but this is actually interesting and I guess useful. So let me just learn it. Let me not judge the book by its cover. You know, what I need to do, read and summarize. I'm going to copy everything that's in here. So let's be positive. I'm going to be learning something new, something relevant in society as well. Hi, Jaden. Oh no, I don't think I don't know. I don't want to do a face quiz. Sorry. Sorry. The European Convention on Human Rights. Doesn't that sound interesting, guys? The European Convention on Human Rights. Your human rights. I should have just read the book by Escobar. This actually sounds quite interesting. So I'm ready to learn. Hope you guys are ready as well. Okie dokie. Let's see what we're going to learn today. So we're going to learn about Article 3, Article 4, 5, 6, Note 7, 8, 9, 10, 11, 12, 13, 14. Okay. Yeah. We're going to learn about absolute rights, limited rights, qualified rights, derogations, and everything. That sounds quite interesting, doesn't it? Oh no. Okay. Let's begin studying. It's 5:30 right now, almost. So hopefully it'll take me 1 hour max. So let me start reading. I don't need to know about the background. Thank you. Need to be speedy with this procedure. Oh my gosh. Procedure. Okay, so there are state applications. State applications. If a state is in violation of ECA, proceedings may be brought against it by another signatory state. State versus another state. Okay. If in violation of European Convention of Human Rights. For example, Georgia lodged during. Oh, it's hot in here. All right. For example, Georgia lodged during Russia's membership 2 separate interstate applications against Russia. The first was filed in 2007 related to the deportation of hundreds of ethnic Georgians by Russia following a row about spying. The second was in connection with the conduct of Russian military forces in the 2008 war between the two countries, Georgia and Russia. Oh, Georgia lodged during Russia's 2 separate interstate. Oh, basically, country against country. Interesting. Tokako. Hi. Yeah, so, okay, this is easy to understand. Next one, individual petitions to the ECHR. Individual petitions to the ECHR, to the European Convention of Human Rights. Individuals which allege that the Convention rights have been breached as a result of domestic law may start their own proceedings against the state. Okay, so this is individual, this state, who claim that the European Convention rights have been infringed. Understand? In Strasbourg, before the European Court of Human Rights. Okay. In the European Court of Human Rights in Strasbourg. I think that's, I don't know. I want to be a lawyer. Oh, that's amazing. Me too. I want to be a lawyer as well. Is it hard? I'm not a lawyer yet, but I'm studying to be a lawyer, and it is kind of hard. It's a lot, but it's doable. So, it's just a lot. I wouldn't say the process, I guess, is hard. It's competitive, but like the work, I feel like if you put in the work, you can get there. It's not like so hard that I can't do it. It's just a lot, and you just have to be good at planning your time and actually sticking to the things and doing it. Thanks for the thumbs up, and thanks for the hearts as well. I really appreciate it. So right now I'm studying about the European Convention of Human Rights. So basically our human rights. And also people bringing claims. Like, can they bring a claim against the country they're in or like countries bringing human rights claims against other countries. So that's interesting, you know. Josephine Morad said hi. Hi, Josephine. Oh, Toka said that's amazing. Yes, it's amazing. Oh, you are my inspiration. Oh, thank you so much. That's so kind of you. Thank you. You can do it. Chase your dreams. Keep fighting for your dreams, and you'll get there. You'll get there. Okie dokie. However, it must be shown that any domestic remedies that exist have first been exhausted. Basically, last resort. Furthermore, there's a time limit requiring the petition to be made within 4 months. Okay. Requiring petition to be made. Petition must be made max 4 months from final decision. Max 4 months from final. So you have 4 months decision. So I guess if a normal person tries to make a European Convention of Human Rights claim against like the country you are in or something, first you must exhaust like the normal courts of that country, and if they don't give you the solution, then you can go to the European Court of Human Rights in Strasbourg. And however, you have to what? You have to make a petition within 4 months from the last decision in your normal court. Okay. Applicants must personally and directly be the victims of the ECHR and must have suffered a significant disadvantage. Wow, this is different from judicial review. I guess for European courts of human rights claims, you must be the actual victim, the one actually getting injured, suffering a significant disadvantage, rather than like a pressure group that has an interest in it. You know, so you have to be the personally affected, not personally and directly, not indirectly. Okay. Applicants must be personally and directly affected by the infringement of ECHR and must have suffered a significant disadvantage. Interesting. Person directly affected and they suffer a significant disadvantage. This is a last resort thing. And you have maximum 4 months from final decision to bring your petition. Okay. Possible remedies could be money, I guess, compensation, or telling the court that country to change their law. That's crazy. Wow. But hey there, Rita. Oh, or requiring. I wonder the implications of this if the UK left the EU. I don't know. I guess it still applies because why is in my book? Well, but my book was made in 2024, and I believe the transition period was it not? I don't know, bro. The Supreme Court relies on the willingness requiring the state to change its law. Requiring the state to change its law. Crazy. So compensation or state change the law. That's the remedy. Interesting. It's important to appreciate that the ECHR is a living instrument in the sense that it has no it has to be generously interpreted in the light of aim to protect human rights. The understanding of which, okay. 2-stage process. There are 2 main stages in cases brought before the court: the admissibility stage and merit stage. Okay, so first you have to have standing, and then there must be prospects. Your case must be good enough. Okay, that's basically what it's telling me. So it's a 2-stage process: admissibility and merit stage. Admissibility stage and merit stage, just like judicial review, kind of. Okay. A single judgment formation will declare an application inadmissible should inadmissibility be obvious from the outset. There is no right to appeal against its decisions. Huh? A single judge formation will declare. Okay, single judge will declare an application inadmissible should admissibility be obvious from the outset. There is no right to appeal against its decisions. Okay. No right to appeal. If declared inadmissible at the outset. Okay. Cases that are covered by well-established case law of the court will be allocated to a 3-member committee, and this is a single judge. So I guess one judge. Cases are covered by well-established case. The court will be allocated to a 3-member committee, which will give final decision on it. Cases that are covered by well-established case law of the court. Cases covered by well-established case law decided by 3 committee members. I guess member states. I guess those are parts of the committee. Other cases will be held by the chambers of judges. Oh my gosh, there better not be a question on that, which will give judgment by a majority. Other cases are heard by chamber of judges, decide by majority vote, I guess, majority decision. The Committee of Ministers of the Council of Europe is responsible for ensuring that states comply with the judgments of the European Court of Human Rights. The Grand General judgment is final. Committee of Ministers of the Council of Europe is responsible for ensuring that states comply with the Committee of Ministers of the Council of Europe responsible for ensuring compliance of member states with the European with the European Convention of Human Rights. Absolute, limited, and qualified rights. This sounds interesting to me. Oh, you are back. Hi, Toka. Oh, thanks for the heart. Thank you so much. You deserve more views. Oh, thank you so much. That's so kind of you. Oh, and what country are you from? And what country are you in? I'm from Nigeria, but the country I'm in is England, Britain, United Kingdom. But I'm in England right now. But I'm Nigerian. That's where I'm from, fully. And I live in England. Yeah. What about you? All right. We're learning now about absolute, limited, and qualified rights. Oh my gosh, I'm Nigerian too, but I live in South Africa. Oh wow, we are Nigerians. Nigerians unite. My name is Chiamaka. Oh, that's very nice. My name is Beatrice. Beatrice. That's a nice name. I like your name. That's so cool. What tribe are you? Which tribe are you? You will have noticed in looking through. I'm Edo. I'm Edo. Yeah. You will notice in looking through that not all convention rights are absolute, of course. Sometimes a public authority may be able to show that it's an action within one of the limitations or qualifications permitted by the article in question and is therefore lawful. You will be looking at some of the limitations and qualifications in more detail later, where it's still important at this stage to understand the general concepts. They are derived from the case law of the European Court of Human Rights in Strasbourg. Convention rights are normally divided into 3 types, okay? Absolute rights can never be interfered. Please don't tell me, no. Talk about it in detail. Oh. Okay. Oh. Wow. Absolute limited. Igbo. Oh, that's so cool. I asked because I could tell from your accent. Oh, really? Oh, that's nice. Yeah, I think I have a bit of a Nigerian accent. Yeah. That's nice. I like Igbo songs. I like Flavor. That Flavor. I like his songs a lot. Qualified rights. Okay. So I guess absolute right is just straight to the point. Why is there a whole different paragraph on qualified rights? Oh, I guess because it's so complicated. So what the heck is limited rights? We're going to find out today. Thank you for the emojis. All right. Absolute rights. So what are absolute rights? These rights can never be interfered with in any circumstances whatsoever. The state must uphold them at all times. Can you imagine? Are you studying for exams or just studies in case? I'm studying for exams. Yeah, I have exams due in less than a month. So I'm studying by force. Yeah, not just for fun. Class can never be interfered with. Rights that can never, I need to emphasize never in my paper. I must not forget this. Never be interfered with. Be interfered with. Hello, Sam. Hello. Thanks for the heart. Got to go. Oh, that's all right. Thanks for joining. Bye. Hi, Sam. ¿Qué tal estás? I'm studying. Gracias. Thank you. Anyways, limited rights. What are limited rights? We're going to find out today. Limited rights. These rights can only be limited in clearly defined and finite situations. Rights that can be limited only, need to emphasize only, in defined and finite situations. In clearly defined and finite situations. For example, what? We'll find out later. What is qualified right? One of the main ones, qualified rights. A qualified right, these rights require balance between the rights of the individual and the wider public. Rights that require balance between the individual interest and public interest. For example, the freedom of speech. I bet that's a qualified right. And some may be interfered with to protect an important general interest or the rights of others. So it may be interfered with to protect the general interest of the public, which is important, an important general, which is important, or the rights of others, like privacy and that. Before you look at the general concept, it's important to establish which rights are absolute, which are limited, and which are qualified. Yes, please. Write that list exceptions. What? You should distinguish between rights that list exceptions to help to define the rights. These are absolute rights that list exceptions that help to define the rights. These are absolute rights as any conduct that falls within any exception does not constitute an interference within the right in question, and rights that list specific and finite situations in which they can be interfered with. These are limited rights as there are set of circumstances where interference is permissible. Rights that list exceptions that help define the rights. These are absolute rights as any conduct that falls within an exception does not constitute an interference with the right in question. Okay? Rights that list specific and finite situations in which it can be interfered with. These are limited rights as there are a set of circumstances where interference is permissible. Isn't that the same as the top one? I'm confused. Rights that are these exceptions that help to define the rights. Oh, that help to define the rights. These are absolute rights as any conduct that falls within an exception does not constitute an interference. You should know that there's a scope of disagreement within the... Okay. Generally speaking, Articles 2 to 7... For example, was it's a universal agreement that Article 3 is an absolute right? What's Article 3? Some sources agree with the above categorizations of Article 2 and 6, but others regard them as limited. Generally speaking, Articles 2 to 7 are absolute and limited rights, okay? Cover the most fundamental human rights and contain either no exceptions whatsoever or narrow express exceptions for limitations. Okay. No, or there are no exceptions whatsoever. Articles 8 to 11, Article 1 cover qualified as. Oh, I get it. Which can be overridden in the public interest. So that one is not a straight yes or no. It depends. So I guess that's why it's qualified. 8 to 11. Okay, so 2 to 7 is absolute and limited. Right. 2 to 7 is absolute and limited. 8 to 11 and protocol 1 to what? Article 1 of Protocol 1. Article 1 is qualified. Interesting. Okay, let's see. Okay, Article 2, right to life. Absolutely. Note that the deprivation of life resulting from the use of no more force than is absolutely necessary is narrowly defined. Because it does not use interference with this. Oh, basically self-defense. Is that what he's trying to say? I don't know. Article 3, freedom from torture, inhuman and degrading treatment, absolute. Article 4, freedom from slavery, absolute, as it should. Note that certain activities are excluded from the scope of compulsory... Note that certain activities are excluded from the scope of compulsory labor and so do not constitute an interference with these rights. Okay. Article 5, liberty and security of the person. That's unlimited. It contains exceptions in relation to lawful arrest and detention. Okay. All right. Article 6, fair trial. Absolute as to a fair trial. Okay. Limited in relation to the trial being public. Oh. Okay. Yeah. Article 7. Punishment according to existing law. What do you mean? Oh, okay. Okay. Basically that the punishment must exist within the law, I guess. Absolute. Note that Article 7 does not preclude that the trial and punishment of acts that are criminal according to the general principles of recognized by civilized nations. Article 8, respect for private and family life. Qualified right. Basically privacy. Article 6, freedom of thought, freedom of expression. Oh, freedom of thought is different from freedom of expression. My bad. Freedom of thought. I'm back again. Hi. Toka said, doing law is nice because it has no math, because I hate math, but I don't fail it because, Nigerian parents. But the subjects you need to do is math. Literally, or core. Or literature, or core. Or core maths. And literature. That is all I know. Also, yeah, in law you don't really have to do maths. That's another benefit. Although I actually liked maths, but now I'm not as good at maths as I used to. But yeah, I understand. But the subject you need to do is math. You need to do maths for law. I think you could do any subject, especially those that those that may help you more is the one that you have to write essays. But you can still do maths as well if you want to. Oh, in South Africa, it's different. And literature. Okay. And literature, that is all I know. Also, you have to do maths and like English literature. Wow. South Africa system must be different. That's interesting. Article 10, freedom of thought is a qualified right. Qualified in relation to manifestation of freedom of worship, teaching, practice. Article 10, freedom of expression, qualified. Article 11, freedom of assembly and association, qualified. Article 12, right to marry, absolute, but according to the national law governing the exercise of the right, okay? Article 1 of Protocol 1, right to peaceful enjoyment of possessions, qualified. Interesting. I need to learn this or create the table. Article 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and then Article 1, Protocol 1. Let's try to remember. And what type of lawyer are you studying to be? I know property and criminal law, but I don't know what others there are. For me, I think I want to be a commercial corporate law. So like commercial, like dealing with contracts and that. Maybe mergers and acquisitions, takeovers and that. Dealing with contracts. Dealing with businesses. There's commercial. There's also intellectual property. Like let's say registering trademarks. Let's say you have a design and you want to protect your design, or you want to bring a claim against someone else because they copy your design. There's like intellectual property lawyers. There's also the one you mentioned, property lawyers. I guess those that help people buy houses, I guess, or help other business buy other properties and get planning permission to do the changes that they want to do. There's also criminal law, those ones that I guess defend their clients and go to courts and advocate in court. Then there's also family law, the one that deal with like divorce or children arrangements, cases for in the house. Maybe the one that deals with families and stuff. There's wills and probate, the ones that deal with the estate. When when someone dies and they wanna the family of the people want to distribute their items to the other family members according to the wills, whether they had a will or not. There's wills and probate. There's also sports law. I haven't studied this one, but I guess for sports, if you're interested in sports and the law in sports, the sports law as well. There is also personal injury. Basically, if you get injured at work or something and then they want to bring a claim against the employer, there's lawyers that help you with that type of claim and everything. There's also employment law. For example, if you were unfairly dismissed from your employment, they sacked you for not a good reason, or illegally they sacked you for an illegal reason, then you could try to bring a claim for compensation, for money from them, or for harassment at work or anything. That's like employment law. There's also mergers and acquisition. A bit like corporate. Basically, if you want to buy a company, you want to buy shares, buy the shares of a company, or buy the assets in the company. There's also commercial business, like let's say a retailer, supermarket, trying to buy potatoes from a supplier and there's a breach of contract or wherever, maybe late delivery and everything. Another supermarket wants to sue the supplier for like maybe the supplier doesn't, or someone doesn't want to pay you back as well. There's claims, I guess, like that. This insurance, there's motor insurance, there's many types of lawyers around. You should check them out. Oh, that's nice, said Toka. Do you know what that I am 11 in 7th grade? That is why I have no friends, because everyone is so mature. And 13. Wow. Then you're 11 and you're already thinking about law. That's so cool though. Oh, you mean you are younger than everyone in your class? Basically, like in Nigeria, I believe in Nigeria, you can already go to university younger than like most people, than the average age that goes to university. Is it like that in South Africa as well? Like you don't have to be a certain age to reach a certain grade. You can just be, as long as you are just smarter and just doing the work, you can just move up grades like that. Oh, everyone is so much. I'm 13. Then don't worry, you can still make friends. You can still make friends. Just find, just maybe put yourself more out there, and I don't know if the society is the only thing that you guys have in common. Maybe you should join it, and maybe try to talk to people there. Maybe by going to societies as well. New society, yeah. I'm 11, not 13. Yeah, yeah. No, you said you're 11. So does that mean are you 11 in a class of 13-year-olds? I see. Oh, wow. Thanks for the 100. Wow. That's impressive. That's cool. You must be very smart. That's so cool. And the way you're even thinking of your future already of law. Not many people know what they want to do at such a young age. So just it's very good that you're already thinking about that. So cool. I see what you mean. I see what you mean. But don't let that get to your head too much. Don't let that get to your head too much. Talk to them maybe as if they're just your regular normal 11-year-olds as well. I don't think it's too much of an age gap. No, 2 years. Actually, yeah. Actually, I don't know. Well, maybe try to go to activities. Yeah, very smart. Maybe you should go to active if your school has like societies or activities that they do after school or during school. Maybe try to join them. Any activity that you actually like, and then in that activity, you probably find people who like the same thing as you, and you try to talk to them about that thing. Sometimes people it's easier to make friends with people who you have something in common with. So maybe that would be an idea that will help you. But yeah, you're very intelligent. That's so cool. I know a lot of Nigerians, I think they do that as well. So cool. Very smart. All right. Article 2. Right to life. Right to life. And this is an absolute right. Article 3. Freedom from torture and inhuman and degrading treatment. Absolute right. Freedom from slavery. Absolute right. What time is it in the Ukraine? Is it 7 p.m.? Here in South Africa is 7 p.m. in South Africa. Oh no, I'm not in Ukraine. I'm in the UK, England. Oh yeah. Sorry, you made a mistake. It's 6 p.m. Oh wow, South Africa is 7 p.m. So I guess there's a 1 hour time difference between South Africa and the UK. That's interesting. Given the fact that South Africa is so at the bottom, whereas UK is near the middle to the top. Is it above the equator? I don't know what the UK is. But yeah, I just know it's a bit close to Europe, close to Spain. I guess above the equator line, or is it below the But yeah, it's so crazy. It's just 1 hour difference. So crazy. Liberty and security. Right to liberty and security of the person. It is unlimited. In relation to lawful arrest and detention. That is an exception. Then there's right to fair trial. Absolute right. As to the point that it is fair. Oh, limited in that it can be in public. Okay. 7. Punishment according to the law is an absolute. Punishment according to existing law. Absolute right. I hope you finish what you are studying and do well. Please stay safe, and I gotta go for bed. Oh, thank you very much. Thank you very much. I hope you do very good as well in all your exams and everything. Thank you so much, and good night. Have a nice sleep. Hopefully you have a nice day today and tomorrow. Thank you. Oh, keep being a star. Oh, thank you so much. Keep being a star as well. And keep chasing your dreams. And yeah, stay more positive always. And have a great rest of the week. Thank you for the hearts. Thank you. It was nice having you on the live. All right. Absolute right. Respect for private and family life. Respect for private and family life. This is absolute perfect, as it should be. Absolute right. Bye. Thanks for joining. Oh, shoot, it's qualified. My bad. It's qualified. Number 9, freedom of thought. Absolute in relation to freedom of thought. Qualified in relation to manifestation. Okay. Qualified in relation to manifestation. Freedom of expression. Qualify right. Freedom of expression. This is qualified. Yes, it is. Freedom of assembly and association. Freedom of assembly and association is qualified as well. Qualified. Right to marry is absolute. Absolute. Oh, according to national law. According to national law governing the system in that country, basically. In that country. Okay. Punto. Article 1, Protocol 1, right to peaceful enjoyment of possessions. Right to peaceful enjoyment of possessions. Possessions is a qualified right. Interesting. Qualified. Okay, finally, we can move to write something else. Oh, my finger. Qualified rights. Qualified rights. Let's see what we got. Must be expressed. Must be expressed. What do you mean by that? Only restriction of qualified rights that are expressed in the E are recognized, and this must be used for the purpose for which they have been prescribed. Only restrictions on qualified rights that are expressed in the European Court of Human Rights are recognized. Only those expressed in the ECHR are recognized and must be used for the purpose of which they have been prescribed. Article 18. Punto. An additional restriction may only be relied upon if it is prescribed by law, has a legitimate aim, and is necessary in a democratic society. It must not be applied in a discriminatory fashion. Okay, so restriction may only be relied upon. Restriction can be relied upon. Maybe, let me write it. May be relied upon. I'm going to write this in green. Prescribed by law. Prescribed by law. Necessary. Okay, legitimate aim. Legitimate aim. And it's necessary in a democratic society. But not in a discriminatory fashion. Not in a discriminatory fashion. So must not be discriminating against anybody when you are rely on restrictions. Qualification will be prescribed by law in accordance with the law. Government can rely on convention qualification to justify a restriction on the convention right only if provisions of the state law actually take advantage of the qualification. What? So, for example, it will not be possible for the UK government to justify infringement of a right to respect for private life on the basis that it was needed for the prevention of crime, unless UK law clearly permitted that infringement. The law giving effect to the qualification may be written or unwritten, but the qualification must be embodied in law. What? Government can rely on a convention qualification to justify a restriction on a convention right only if provision of the state's law actually take advantage of that qualification. So, for example, it will not be possible for the UK government to justify infringement of the right to respect for private life by telephone tapping on the basis that it was needed to prevent crime unless the UK clearly permitted the infringement. Oh, I think I get what you mean. Do I? So basically, it must clearly be the local law must clearly permit the infringement. Okay. Must be by prescribed law. Must be prescribed by law. Talking about the qualifications. So basically, UK law must clearly permit the infringement. UK law must clearly permit the infringement, and the law can be written or unwritten. The law can be written or unwritten. Interesting. Moreover, the law must be accessible and sufficiently precise to enable the citizen to rely on it. The law must be accessible and sufficiently precise to allow regulation of one's conduct. Punto. It said here that English law on telephone tapping was not clear enough at the time to provide a sufficient legal basis for a restriction on the right to sufficient legal basis for a restriction. Remember, the law must be accessible. Held that English law on telephone tapping was not clear enough at the time to provide a sufficient legal basis. While the English law on telephone tapping was not clear enough that at the time to provide a sufficient legal basis for a restriction on the right to respect of private life. For example, telephone tapping is not enough. In this case of multiple sclerosis suffered by Debbie Polly, the absence of crime-specific policy relating to assisted identifying the facts and explaining that the data police will take into account when deciding whether to prosecute an individual for assisting another to commit the statutory offences of was in accordance with the law for the purposes of Article 8.2. Accordingly, the mandate to abolition of her right to lead a private life. The existing law was especially clear about the factors that they will take into account, and therefore a person could not accurately predict if they were likely to be prosecuted with assisting. What? In the case of... What right is it again? Okay. In the absence of... Relating to the facts of children, the will take into account in deciding whether to... Offense of... was not in accordance with the law for the purposes of Oh, the normal is sufficiently clear. Okay. Legitimate aims. Qualification must be defined by reference to the aim specified for each right. Interest of national security, public safety, and economic well-being of a country. All right. This is gonna be long. Let me see how many pages I have left. A lot of pages, guys. A lot of pages. I think I don't know if I'll finish this today or not. Thank you for the thumbs up. But yeah, I'm gonna end the live now and continue off camera, or I may take a break. Thank you guys for joining. See you guys in the next live. Bye.